Good morning, everyone. Merry stupid o'clock and a very early happy Halloween. Welcome to another episode of Spilling Tea. I am your host, Tiffany Daniels. And yes, folks, this side, pajamas. I went the lazy route for Halloween this year. Hi, I'm a toddler. This means I get away with wearing nothing but pajamas all day. Yes, that is literally the reason why I chose to be a toddler. Bleh. We are going back to that horrible world known as the JRC. But before we get started, the usual disclaimers. First off, you are going to see a link to this particular article we're going to be looking over right there in the description box, along with the other pertinent links to the Stop the Shocks campaign, including Autistic Hoya's massive archive on the subject, the ASAN templates, sign your name, click on your senator. It takes 2 minutes. We want to get pressure on the Senate up in Washington to get them to end adversive punishments and improper restraints in schools and seclusion. Also, we have the ever-present change.org Shut the Judge Rotenberg Center Down petition. All right, folks, when we are talking about the JRC, you're going to hear vivid descriptions of, as well as see clips of video surveillance footage of people with disabilities being tortured and abused. If you have young children present, please use your headphones. And folks, it's 4:25 a.m. in the morning. I do get up an hour later on Sundays, but don't make you think that that means I got more sleep. No, I didn't fall asleep till God, I don't want to discuss it. If I stumble over any words, please, my apologies in advance. Now, what we are about to read is in regards to a attempt to go ahead and amend or absolutely get rid of the consent decree that we were reading over for the last 3 days. So, court hearing on October the 26th. This is as of October the 12th, 2015. So, we're going to go ahead and read it here. All right. So, this is written by Lydia Brown, by the way. Now, content warning. Fairly descriptive discussion of torture and abuse of people with disabilities using electric shock in an institution. And yes, JRC, you are an institution, not a school. Get over yourself. All right, so there was a court hearing about the Judge Rotenberg Center, JRC, scheduled to begin on Monday, October the 26th, 2015, in the Bristol County Probate and Family Court in Taunton, Massachusetts. Arguments are expected to continue for around a month. If you are able to attend or part or all the hearing, which is open to the public, please do so. We need advocates in the courtroom. Obviously, we can't time travel. I mean, after all, we're not AH. So this is just kind of her going over things. This post is an explanation of why this is so important, what the hearing is actually about, and for the uninitiated, what the JRC is. It starts with some background about the JRC, then gives the legal context. So we've gone over the background numerous times, but for the sake of the article, yes, we're going to read it again, folks. This is, of course, Lydia Brown and some of the other folks outside the JRC. It looks a little sparse, folks. We need more people, obviously. We're tired. Background. The Judge Rotenberg Center was originally founded as the Behavioral Research Institute. Obviously, since we read the 1988 decision, you saw that. It didn't start shocking people, as it is now infamous for doing, until 1988, so not long after they got that settlement. Why am I not surprised? But since its beginning in 1971, founder Matthew Israel instituted a regime of pain to coerce behavioral modification for children, youth, and adults with intellectual, developmental, and psych disabilities committed to his care. Food deprivation, prolonged restraint, seclusion, which is ultimately a form of solitary confinement in the name of treatment, forced inhalation of ammonia, sensory assault with the notorious white noise blasting helmet, slaps, pinches designed to maximize pain by digging nails into the muscle. Since 1971, 6 people receiving treatment at the BRI/JRC have died in their care. Robert Cooper, 1980. Danny Oswald, 1981. Vincent Militek, 1985. Silverio, Silverio Gonzalez, 1998. Linda Cornelison, 1990. And Abigail Gibson, 1997. Brandon Sanchez was the first resident to be subjected to electric shock. The device was called the SIBIS, Self-Injurious Behavior Inhibiting System. Although the staff at BRI/JRC have long known that darkened, cool, low stimulation environments help Brandon Sanchez self-regulate and decompress, they began to treat his extreme self-harm by shocking him under the belief that the association of unwanted behavior with painful stimuli would decrease the unwanted behavior, which is insane. Insane! That's the same justification they used to use for spanking, folks, just in case you wanted to know. In other words, it's like applying dog training tactics to humans, or at least humans deemed subhuman. And remember, they don't even do that to dogs now, but they still do it to us. On one day, he received over 5,000 chalks from the SIBIS in a single day. After that, Matthew Israel asked the SIBIS manufacturer to build a stronger device. That doesn't sound like it's psychotic, folks, to you. I worry about you. They refused. Matthew Israel invented his own device, the Graduated Electronic Decelerator, GED, which emitted a stronger current and shock than the SIBIS. The GED works by strapping electrodes on the person's arms, torso, and legs, which are activated when someone presses a button on a remote control. Over the past couple decades, the GED has gone through several iterations, each more powerful and painful than before. The present model in use, the GED-4, is designed to be more powerful and painful than a police taser. Think about that. Theoretically, the therapy is used to reduce or eliminate dangerous or aggressive behavior, like someone picking at their eyes and causing a vision disability, or someone banging their head against a wall and causing a brain injury, or someone physically attacking other people. In reality, the aversive electric shocks are given for behavior ranging from closing eyes while walking in the hallway to trying to hold a staff person's hand, or from getting out of the seat without permission to use any swear words, or simply for non-compliance. My God, they would have never let me off the board. Curse like a sailor. So basically, everything that they do on a semi-regular basis when not on freaking shift, we get punished for. In April 2012, a medical malpractice lawsuit brought by the family of Andre McCollins went to trial before a jury, where video footage of shocks was played public for the first time. 10 years before, in 2002, Andre McCollins, a black autistic teenager with the other cognitive and psych disabilities, had been shocked 31 times in 7 hours while restrained face down in 4-point restraints. The long shock session stemmed from a brief verbal interaction with a staff person who told him to take off his jacket, and he dared to say no. The shocks are as much for non-compliance as they are for anything else. Like speaking out. Since 1971, dedicated advocates, including titans like Nancy Weiss, Freda Brown, Polly Zane as Cobb, have fought to close the JRC and end their abusive practices. Survivors like Jennifer Masumba and Ian Cook testified in front of the U.S. Food and Drug Administration. Disability rights organizations across the country have reportedly condemned the JRC, along with the current and immediately former UN Special Rapporteurs on Torture. But legislation has never made it through the Massachusetts State House. Congress has never passed any measure that would ban adversive and dangerous restraints and seclusion. Which, folks, that is still true by this day. To this very day, there is no protections for us in regards to that. None. And people die every year from improper restraints. Don't believe me? Look it up. The U.S. Department of Justice Civil Rights investigation has produced no fruitful results. The FDA has never issued a decision after hosting a public hearing about the possibility of banning electric shock aversives, which they did pass it, and then it was overturned by the D.C. Circuit Court, which is why we are where we are today. And Massachusetts regulatory agencies, Department of Developmental Services, formerly Department of Mental Retardation, Office of Children and Families, etc., have been almost totally unable to do anything about the JRC because of the Massachusetts courts. Basically, they have their hands tied completely. This explanation continues below the pictures. God. Look how young. Look how young. Legal context. In 1986, the Massachusetts Office of Children and Families tried to yank the BRI's license to operate, while issuing emergency orders essentially telling BRI to get its act together. In response, BRI sued the state government, accusing it of acting in bad faith and abusing its power to regulate by targeting just this one institution, and thereby violating the rights of the students and parents for them to receive treatment at the BRI. God, these people are psychotic. That's what y'all call treatment. Screw you. When the cure is worse than the sickness. Just saying. The case settled with a consent decree in 1987, that's what we've recently gone over, which means that the court where the lawsuit was filed, Bristol County Probate and Family Court, as mentioned above, still has control of the case, as opposed to it being considered totally closed at the base court level. The consent decree was supposed to last for 1 year, as we have read. It allowed BRI to keep operating as usual, but with one change. If BRI wanted to subject anyone to invasive aversive treatments, it had to go to court and ask a judge to allow them to add aversive treatments to the person's individual treatment plan. These special hearings are called substituted judgment proceedings, where the judge makes a decision about treatment based on what they think a disabled person would decide if they were competent. Yeah, if that's not fucking ableist and elitist as hell, I don't know what is. It's an incredibly ableist legal construct, but that's a topic for a whole other post. Amen. In theory, those substituted judgment proceedings are supposed to be adversarial, meaning that the outcome could go either way. Maybe shock is added to the treatment plan, maybe not. In reality, since the institution of the consent decree, the judges in Bristol County Probate and Family Court have basically rubber-stamped every BRI JRC request to add electric shock to someone's treatment plan. Yeah, every fucking time. These kids got no protection but us. None. None. This is why this is important, folks. This is why tirelessly we continue to work. They've got no one on their side but us. The consent decree was indefinitely extended instead of ending in 1 year and is still in force. This is how they win their lawsuits, folks. This is what we're up against. This is the level of corruption, ableism, hatred, and bigotry we have to deal with and face every day. And people wonder why my ass is antisocial. BRI changed its name to the Judge Rotenberg Center to honor the judge who oversaw the consent decree. Once he died, and it no longer looked totally weird to name the place after him. In the mid-1990s, the Department of Mental Retardation, now the Department of Developmental Services, denied JRC's request for certification to use certain adversives, including electric shock. So JRC went to court, and DMR was held in contempt. Good God! The commission was forced to resign. The DMR was placed into receivership, with an outside person appointed by the court to take over everything DMR did involving the JRC for 10 years, 1996 2006. The level of power that JRC is allowed is completely astounding to me. On 14th February 2013, the Massachusetts Attorney General's office filed a motion to vacate the 1987 consent decree. If granted, the motion means that everything in the consent decree now becomes null and void, and the Bristol County Probate and Family Court will no longer have control of the case. The court has also the option of allowing the motion in part, but not in whole. Overall, this means that there is a decent possibility that the JRC could lose the protection it has enjoyed for almost 3 decades from the courts, which they are still getting. The hearing scheduled to begin on October the 26th was an evidentiary hearing on the motion. The state's attorneys will present evidence in support of their motion to vacate, probably by arguing that the consent decree is irrelevant both in a regard to how the state's agencies regulate JRC and what treatments are considered acceptable for people with intellectual, developmental, and psych disabilities. JRC's attorneys will, of course, argue the opposites. So so that happened. And of course, with JRC's power, they were able to quash it. This is what people like me get to live with every single day. That we are under the complete control of and are utterly powerless against these outdated, over 30-year-old decisions that strip us of our autonomy, call us incompetent, put us under the complete control of the courts, and then the courts hand us over to places like the JRC, where they are able to torture and abuse, harass, and utterly traumatize us with impunity. This is what we're up against. This is what the DC Circuit Court decided to protect instead of enforcing the ban back in 2020 when they were fucking supposed to. We are literally the only chance these kids got. That's it. It's just us. You can see why we are so exhausted. We have been trying to get people to care about what's happening to those kids for over 30 years. It is 2021 and this place is still allowed to do these things, and they are never punished for it. They have never had their license revoked. If it was a decent world, it would have been yanked a long time ago. This is why we need you. In order to get the kind of pressure that will hopefully embolden some people on the federal level, we've got to put the pressure on. And it can't just be us. It's an ableist world, folks. And all they ever say when they talk about us who have fought this fight so long is that, well, we're disabled, so we just don't understand. This is helping them, but we don't get it. But that's okay because we're disabled. And you know, your parents can send you to us and we'll fix you. Yeah, we need outsiders. So please spread these articles around. Talk about this case. Talk about it with strangers. Help assist us against this freaking gigantic Goliath which hangs over every single autistic person in the state of Massachusetts. And on those notes, I'm going to go ahead and close out this morning. We don't get very many views on this channel, especially on this subject. The few that we do get do tend to get removed from time to time. So folks, please don't forget to hit that like button. Hit subscribe. Don't forget to hit the comments. And folks, please share this. Share that live video of what happened to Andre McCollins. Share these articles. Share my videos. Share other advocates' videos. Share everything on the JRC you can find and get out and reach it to as many people as you can. We need this viral. We need it on social media. We need it in the damn news. We need to hear about it in the streets. Everywhere we can get it so the JRC realizes the world knows what they are doing to those kids, and we will not tolerate it. All right, folks. Again, thank you for spending some time with us this morning. All right. Goodness, sorry, my brain. I do appreciate your time this morning. And as always, we here at Spilling Tea hope you have a good one. And happy Halloween, everyone. Bye-bye.